Good day, everybody. My name is Taryn Fritzgerald. I'm a civil legal practitioner with Legal Aid South Africa. I am based at the Pinetown local office. I primarily deal with civil law, family law, which includes parent and child, domestic violence matters, and protection from harassment matters. In our civil unit, we deal with a lot of domestic violence matters. We deal with a lot of protection from harassment matters. The places that we cover, well, the jurisdiction that we cover has a lot of these matters at the moment. They're very prevalent in our society, and we see a lot of these matters coming in. We try to advise clients when they come in for these domestic violence queries or matters which are already in courts, that there are certain steps that they need to follow, whether it is them looking to apply for protection order or whether it's them looking for legal representation. So let me deal with the Domestic Violence Act first. And I'll detail to you what type of matters fall under the Act and what legal advice it is that we give to clients who are seeking to apply for protection order. So the Domestic Violence Act came into effect on the 15th of December, 1999. The purpose of this act was to afford victims of domestic violence the maximum protection from domestic abuse that the law can provide, and to introduce measures which seek to ensure that the relevant organs of state give full effect to the provisions of the Act. It also seeks to ensure that domestic violence is recognized as a serious social evil due to the fact that there's a high incidence of domestic violence within South African society, and that the victims of domestic violence are among the most vulnerable members of our society. Domestic violence itself takes on many forms, and the acts of domestic violence may be committed in a wide range of domestic relationships, and that the remedies currently available to the victims of domestic violence have proved to be ineffective. Let me just define the domestic relationship as is contained in the Acts, because people are not always clear on what a domestic relationship is and whether or not they fall under the Domestic Violence Act when bringing or applying for the application for the protection order. So domestic violence is defined as a relationship between a complainant and a respondent in any of the following ways. Number one, where they are married or were married to each other, including any marriage according to any law, custom, or religion. So it's not only a civil marriage, it could be a customary marriage. It could also be a marriage that is concluded in terms of any religious rites, should I say, where they are of the same or opposite sex, where they've lived together or are living together in a relationship, which is not necessarily a marriage, although they were not and are not married to each other or are not able to marry each other. That's number two. Number three, where they are parents of a child or are persons who have had parental responsibility for their child. So this could mean that it's a foster parent or an adopted parent or a step parent. Number four, where they are family members related by adoption, affinity, or consanguinity. Number five, where they were in an engagement, where they were dating, or where they were in a customary relationship. And I think that's also important for our listeners to understand, that it doesn't matter that you're not living together. It doesn't matter that you're not married to each other. If you were in a relationship with that person, you can apply for a domestic violence interdict, or rather protection order. This could be an actual or perceived romantic, intimate, or sexual relationship of any duration. So whether it be that you are involved in a relationship with somebody for 1 or 2 weeks, or a year, or 5 years, it still falls under the definition of a domestic relationship. And lastly, where they share or recently share the same residence. So if you and I are staying together, whether it be cousins or mother and daughter or boyfriend and girlfriend, you can apply for the protection order. Now, domestic violence, we need to fully understand what domestic violence is, because people don't understand that. They think if they're living in a relation, if they're involved in a relationship rather, and they are being, and I'll use the colloquial term, where they're being put down by somebody. They are constantly being told, you're not good enough. You should look like this. You should dress like this. You're not a woman. You're not a man. You know, you're nothing. You're useless. That can fall under psychological abuse. People don't realize that that is abuse, and they take it for years on end, not knowing what they can do or what remedy they have at their disposal. And this is all covered in the Domestic Violence Act. You can actually apply to courts to ask the courts to protect you from this person in this way. And the court will grant you the relief you seek, as long as you show the court that this is what's been happening to me. Now, domestic violence means, one, this is what's covered under domestic violence. It's physical abuse, it's sexual abuse, it's emotional, verbal, and psychological abuse. It's economic abuse, which is what some people don't think of when they think of domestic violence. If you're dependent on somebody financially, and that person is withholding funds from you, for instance, during lockdown, if your partner's working, you're sitting at home, you don't have a job, you've always been a housewife, for example, and he's withholding funds from you, and you've got no way of making money. Before lockdown, for instance, you would go out and perhaps you would sit at the school and make boerewors rolls and sell it to the community or to school kids. Now you don't have that income. You can't make a profit because you cannot go out and do that because of the regulations. And this person knows this very well, and they're not assisting you financially. That is economic abuse. The next one, intimidation, harassment, stalking. Your partner and you could be separated, or you could be living together rather, for a better example, and you go out and he follows you around, he stalks you wherever you go. He goes through your phone, watching your movements. I've actually had clients like that, where the husband's an IT technician and he's gone into the wife's phone and he actually checks where she's going. He's got a location tracker on her. Damage to property. Any entry into the complainant's residence without consent, where the parties do not share the same residence. So if, for instance, you're going through a divorce and he's moved out, you can ask under the Acts that this person does not enter your residence without your consent. Also, it's any other controlling or abusive behavior towards the complainant, where such conduct harms or may cause imminent harm to the safety, health, or well-being of the complainants. What you can also do when you're applying for the protection order in your papers, and I'll go through that in a minute, is you can ask the courts for emergency monetary relief as it applies to economic abuse. You can ask the court for the respondent to compensate you for any loss that you've suffered as a result of the domestic violence, which includes, for instance, loss of earnings, medical and dental expenses, relocation and accommodation expenses, and household necessities. Now, the example I used was the couple that are separated, and you're asking the court for them not to now have entry into your residence. Now, say, for instance, that one of the things that happened was that this person physically abused you, your spouse abused you, and you couldn't go to work. You were off for like 2 weeks because you had a broken limb and blue eyes and broken ribs. So obviously you've got no income. you had medical and dental expenses due to the fact that you had to go to doctor, or you had to pay for your tooth to be fixed. You've now had to move out yourself or find somewhere else to live. You can ask the court for that emergency monetary relief from the respondents, and they need to pay to you as part of the interim protection order when you make an application. Okay, moving on. Let me just touch on harassments. Harassments it forms part of domestic violence. However, there's also a separate act, which is called the Protection from Harassment Act, which deals with incidents where parties are not related, where, for instance, your neighbor is harassing you, or some arbitrary person that has fallen deeply in love with you on social media decides to stalk you, and you find out who this person is, then you can apply for a protection order in terms of the Harassment Act. I just want to go through that and just mention quickly what harassment actually entails in case people aren't aware of it or they don't know what it is. Harassment is defined as where persons are engaging in a pattern of conduct that induces the fear of harm to a complainant, which includes repeatedly watching, loitering outside of or near the building or place where the complainant resides, works or carries on business, or studies, or happens to be at that particular time. Repeatedly making phone calls. Now in our age, we've got caller ID, which you can switch on and you can switch off. You can phone from private number as many times as you wish, and the person will not know who you are. And a lot of times, this is what happens when people are harassing. They put their numbers in privates and they start going to town, harassing the person. It also includes inducing another person to make telephone calls on your behalf to the complainants. Whether or not the conversation ensues is by the way, but the fact that this person is harassing you telephonically, repeatedly sending, delivering, or causing the delivery of letters, packages, faxes, emails, or any other object to the complainants. That is the definition of harassment. Now, when you decide that you want to actually apply for the protection order, or you're going through this process of you're going through this abuse and you decide you want to do something about it, the first thing you can do is that you can approach the SAPS in the area where you reside. You can go to the South African Police Service. When this incident of domestic violence occurs, you can tell them that this is what happened, and they are able to render assistance to you, which is required in the circumstances. And this includes assisting or making arrangements for the complainant to find a suitable shelter or to obtain medical treatment if need be. The peace officer may, without a warrant, arrest the respondent at the scene of the incident of domestic violence if that arresting officer feels or reasonably suspects, of the respondent having committed an offense containing any violence element against the complainant. So if they suspect that this person has actually physically abused the complainant and this person is walking around with scars, and you can actually see that there's evidence of abuse taking place without a warrant, they can be arrested. With regards to applying for a protection order, what you'll need to do is you'll need to go to the magistrate's court in your jurisdiction. And the complainant may approach the clerk of the courts, which is the domestic violence courts. They will be assisted in filling out the application for protection against domestic violence. They will be told that they also have the right to lodge a criminal complaint against the respondents if there's a criminal offense which has occurred or been committed by the respondents. They will advise them of the relief available in terms of the Domestic Violence Act. This application can be brought on behalf of the complainant if they are unable to do so. Normally, it's the complainant that will approach the clerk of court. If they cannot approach the clerk, for instance, just say that they're in hospital because of the severity of their injuries due to the physical abuse, they can be assisted by a counselor, a health service provider, or a member of the South African Police Service, a social worker, or in cases where it's a minor child, a teacher can approach the courts and make application on their behalf, as long as the person making application on their behalf has a material interest in the well-being of the complainants. If that person is making an application on behalf of the complainant, they need to have written consent of the complainant. There's exceptions, however. The exceptions are where the complainant is a minor. That's where the parents or guardian or a teacher or social worker can make application on their behalf, or where the persons are mentally retarded, or they are unconscious, or where it's made by a person whom the court is satisfied is unable to provide the required consent. That could be probably hospitalization due to operation. Okay. Now, when they're making this application, the clerk of the court will go through the application and fill out the necessary details such as their physical address, their name, their particulars of where they live, who they live with, who has been affected by domestic violence. They will also ask for a history of domestic violence which has occurred. They ask for a background history. And what you can do then is you can actually attach any supporting affidavits by any persons who have knowledge of the abuse that has been inflicted upon you. Or you can attach photographs, or if you've got video clips or sound recordings, voice recordings, you can attach it or make reference to it and say it's on a USB stick. You can later make it available for the courts, as the matter progresses. But as long as you put all that in the beginning, you have to have a complete history. What I normally tell my clients is that think of it as a story. Think of, I don't know, Snow White. Start at once upon a time. Once upon a time, I met so-and-so. We lived together, we got married, we had a relationship, we had a child. And this is what followed. Give a complete history. So you detail the abuse that's happened throughout the time that this has occurred to you. And you don't just isolate it to a specific event, because it doesn't show that this person has continuously and repeatedly done this to you. He's repeatedly victimized you. He's repeatedly abused you physically, emotionally, psychologically. So when it comes time to him defending the application, opposing the application, he's got to make reference to each allegation that you've raised. He's got to now contradict, or he's got to defend or oppose and give reasons why. You strengthen your case more by expounding upon the actual events that occurred in your life, which led to this stage. Okay, so it's very important that you actually, if you're not sure, ask the clerk of the courts, or you can seek legal advice. And we always give legal advice to those that wish to approach us as legal aid. We have walking clients that come through. We assist them. We've got an advice line where you can phone in. We've got a please call me service where you can send a please call me and our call center will call you back. And if you live in Durban or Pinetown, for example, we'll be able to assist as the nearest office which is located to you. So you have those remedies. You've got those avenues to approach and seek legal advice, not necessarily from the court itself. Okay, so as soon as you've made a case for the protection order and you've written it down and the clerk is satisfied that everything is in order and you are sure that you've got all your ducks in a row and you're fine with your papers as it is, the papers will then go to the magistrate that is assisting on that day with new applications. And the magistrate will look at your papers and they will see whether or not you've made a case out for an interim protection order. So if your case is really strong and you feel that you've made out a solid case and the court, the magistrate can see that this person has gone through X, Y, and Z and she is perhaps she is fearful for her life, or there's been physical abuse and now the respondent, for example, is now arrested, he will grant the interim order against this person, against the respondents. And once that interim order is granted, it needs to be served on the respondents. Okay, so on the interim protection order, it will have a return date. So it will state there when the respondent has to appear in court. The papers will go via the sheriff of the court for service on the respondent, or it can be sent to the SAPS. They can take it out and they can actually serve it on the respondents for you. Perhaps if they need assistance, they may ask you to do a pointing out, which means you will go along with them, not necessarily in the police van, but in your own private vehicle, and just do a pointing out and say, that's the person, and then you can leave, and they will serve the papers on the person, and they will sign a return of service. So that's what you will take then back to the courts. Now, when the interim protection order is served, it will be served along with a warrant of arrest. That will stay, that goes hand in hand with the interim protection order, and it will be served on him. It will also be kept in the court file. Now, the reason for the interim protection order, let me just explain the relevance of it. That interim protection order is actually giving you immediate relief, which is what you want, which is why you went to the courts and said, you know what, I need help, I need protection. So on that interim protection order, it will be section 5 or 6 of the protection order. It states that the respondent is prohibited, and the magistrate will sign according to what you've written on there. What don't you want him to do? What don't you want her to do? Let me not be gender biased. What you want that respondent not to do? You don't want them to, 1, commit any act of domestic violence. So these sections are basically prohibiting the respondent from committing any acts of domestic violence, enlisting the help of any other person to commit any such act, because we both know, sorry, not both, we all know that I don't have to necessarily come and do anything to you. I can speak to a friend. I can get the friend to come and, start something with you. It also prohibits the respondent from entering your residence. It prohibits the respondents from entering a specific parts of a shared residence. So you may live together. You may be married, you both own the house, but you will ask for him not to come into this room, that room, or stay on his side, I stay on my side. Okay? And also, you can ask for the court to prohibit him from entering your place of employment. The court may also impose additional conditions which it deems reasonably necessary to protect and provide for the safety, the health, or the well-being of the complainants, and they can include in an order to seize any firearm or dangerous weapon in the possession or under the control of the respondents as soon as that interim protection order has been granted. A SAPS member may also accompany the complainant to the specified place or residence that they share, to assist with arrangements regarding the collection of personal property, for instance, your clothing, where you've been denied entry, or you as the complainants have been kicked out of the house and all your belongings are still in the house and you need to remove your belongings. They can make that order to say that you need your belongings, you need your jewelry, you need your laptop, you need whatever it is that has been left behind. And the court, as I stated earlier, can make an order regarding emergency monetary relief, and that will be in your interim order. And this will be relief with regards to your financial needs and your and resources of the complainants and the respondents. And such order has the effects of a civil judgment of a magistrate's courts. So that's something to note. It has the same effects as a civil judgments, and it needs to be abided by. What you can also ask the court to do in that interim order, if you fear for your life, if you don't want the respondent to know where you're staying, is you can ask the courts that your address, your physical address, be omitted from the protection order. More often than not, you find a lot of clients actually saying that I don't want this person to know where I stay because I am so scared that he'll find me and he'll do something to me. And that's a genuine concern that a lot of people have. With regards to the warrants of arrest, whenever a court issues a protection order, the court has to make an order authorizing the issue of a warrant for the arrest of the respondents. Now, the warrants of arrest will be suspended. It won't go out to the police and then automatically the respondent is arrested then. But it will be authorized, and the execution of the warrants itself will be suspended, provided the respondent complies with the prohibition and the conditions contained in the interim protection order. Now, when the respondent has to go against the interim protection order and he violates it or breaches it, the clerk of court can then issue a second or further warrant of arrest. Okay, so the warrants of arrest will be taken by the complainants to the SAPS, together with an affidavit stating that the respondent has contravened any prohibition, condition, obligation, or order contained in the protection order. Okay, so they'll take that directly to the police station. If it appears to the member, which is the South African Police Service, that there are reasonable grounds to suspect that the complainant may suffer imminent harm as a result of the alleged breach of the protection order by the respondent, the police officer, or member rather, must then immediately arrest the respondent for allegedly committing the offense. Now, if he finds that there are insufficient grounds for the arrest, he or she must immediately hand a written notice to the respondent. You see, there's a difference. So if he can already see that there's imminent harm, if he suspects that there's imminent harm or that this person, the respondent, has breached the order, he will arrest immediately. However, if he sees that there's not sufficient evidence for arrest, he will then hand a written notice to the respondent, which will specify the name and the residential address and the occupation of or the status of the respondent, and it will tell the respondent to appear before courts and on a specified date and time, which will be stipulated in the notice, on a charge of committing the offense, which will be the breach of the interim protection order. Whenever that warrant of arrest is handed to a member of the South African Police Service, the member of the SAPS must inform the complainants of his or her rights to simultaneously lay a criminal charge against the respondents. So it's twofold, okay? So they will appear in court for breach of that order, and then they also have the option of laying a criminal charge for the offense committed. With legal aid is that we've got very strict Guidelines. We've got guidelines when it comes to everything. When it comes to maintenance, when it comes to domestic violence, civil is basically broken up into different parts. So for domestic violence matters, what happens is that if you come to us and ask for advice, we will give you advice. We've got the various options that you can, the various avenues you can approach, whether it be the toll-free line, the please call me service, or going into your nearest local office and seeking advice when you walk in. However, now due to the coronavirus, we aren't taking in clients directly off the street. So you'll have to make an appointment with our toll-free line, our call center, and they will direct you to the relevant office. But what happens is that if your matter is already in courts, we don't assist from the inception of the matter. We don't take you to court and make application for you or to assist you in filling out the papers. The clerk of court will do that. You will be given your return date when you come to court. When your matter will be first heard, that will be your first appearance. Thereafter, if you find that, and the magistrate will tell you, you are entitled to legal representation on your first appearance. Thereafter, if perhaps the respondent goes and gets a private attorney, he mandates a private attorney to represent him, then you can come to legal aid for us to apply for legal aid firstly, and then once granted, and a legal representative will be allocated to you, and we will then represent you. Or if the complainant goes to a private attorney, you as the respondent can come to us, and we can assist you after you make application and you go through the various means tests, and your application is then granted if you meet all our requirements. But we don't represent you from the onset. We only come in at the stage where the other party has been represented, is represented legally by a private attorney. So it'll never be legal aid on board first. It'll always be a private attorney representing either the complainants or the respondents. Thereafter, you'll inform the court that, I would also like legal representation, and I cannot afford a private attorney, therefore I'd like to apply for legal aid. Then the court will direct you to our offices, whether it be in Pinetown, Durban, Johannesburg, Grahamstown, wherever you live, for example. And you will go through the process of applying and your application being granted or whatever the case is, and you'll be allocated an attorney, or as we say now, legal practitioner. As I mentioned earlier, should you seek legal advice, you may contact our toll-free Legal Aid South Africa advice line on 0800 110 110, or you can send a please call me to 079 835 7179. I hope that this has been informative and you've enjoyed listening. Thank you so much.